XRP holders, we just got breaking news. Is the SEC officially filing for an appeal? There were some fakes earlier today, but right now it's been confirmed. 20 minutes ago, breaking news. And guys, I'm getting out of bed for this one, so go ahead and press that like button right now. The SEC files a letter outlining its basis for filing a motion for leave to file an interlocutory appeal regarding programmatic offers and sales to XRP buyers over trading platforms and Ripple's other distributions. The SEC seeking a stay of all proceedings pending appeal is not unexpected. And this comes as a response from James in December of 2022, when somebody asked if Ripple gets outright victory in the lawsuit and the SEC appeals to appellate court, what happens in the meantime? Does Ripple have green light to operate in the US until the final decision is made? And James said the SEC will ask to stay the judgment pending its appeal to the Second Circuit. That means it'll ask the court not to enforce the judgment until the appeal is over. That will be an epic battle between the parties, and whether the court agrees to that remains to be seen. And just to quickly note upon it, XRP has fallen from about 65 cents, 3% down over the last hour, to roughly 63.7 cents. Not too much down, but the people are feeling a slight shock. As you can see right here, almost 66 cents and just a couple percent down, 3 or 4% or so. And like I said, the last couple of hours have been very confusing, all right? A couple hours ago, this came out. Judge Torres has issued a pre-trial scheduling order saying that the court will seek to schedule a jury trial for the second calendar quarter of 2024. So that is with regards to everything else in the lawsuit that will all come to light at the end of 2024. But on that, I'll make another video later explaining more about all those details, probably tomorrow. A little bit afterwards, an hour ago, Mark Jones and Peter Moores have filed motions to appear pro hack Vice on behalf of the SEC. I'm assuming that that's because now the calendars have been set, and so the SEC came to hop on in. Or, all right, with our knowledge that we've got now from about 20 minutes ago, as we just saw, the SEC filed their motion to basically go for an appeal. And I'm just checking out all the other lawyers, and everybody's been talking about everything Ripple SEC related. Today is a big day. And guys, like I said, make sure you go ahead and press that like button. A couple of hours ago, there was a fake proposal going around. And now, with the information in hindsight, I'm thinking, what if the SEC did this themselves to make us happy with a dead freaking horse? What I mean is, a couple hours ago, a posting went around, and Jeremy said the posting is fake. But that being said, if the SEC is going to file an interlocutory appeal, I would expect it to be filed this week. All right. And a couple hours after he said that, it happened. But that was basically a little piece where the SEC supposedly said, hey, Ripple, we give you the win. All right. We're keeping this all out of the way. The SEC decides not to file an appeal. And it's quite interesting that the exact same day, a couple of hours after this went trending, all right? I didn't cover it because I thought it wasn't a big deal. A fake little posting of no appeal, oh, blah, blah, blah. But all of a sudden, an actual appeal was filed. So Jeremy Hogan said, and the SEC continues to make questionable decisions regarding an interlocutory appeal. Note that this is not appealing whether XRP itself is a security, just its losses on the programmatic and individual sales issue. So let's take one thing quickly, all right? Let's input this quickly. Ripple is in an ongoing battle with the SEC. They've got something scheduled for the end of next year, which is basically the fight that they still have got ongoing with regards to Brad and Chris Larson, all right? The individual defendants that will go to trial. What is being fought by the SEC, what they're appealing, all right, has to do with these programmatic sales from Ripple that the SEC lost on also. This is not about whether or not XRP, in this case here, is a security. This is about, again, when Ripple was basically allowed to sell XRP around. It still, regardless of all this, does not make XRP itself a security. The SEC is trying to get Ripple more at blame. I'm guessing actually that the SEC just waited to file this appeal until the scheduling order came in, because that just makes a lot of sense, right? That they waited for the schedule to be set before basically coming in with the hammer. All right, they said interlocutory review is warranted here. And what it's about, specifically the SEC seeks to certify the court's holding that defendants, Ripple, Chris Larsen, and Brad Garlinghouse, programmatic offers and sales to XRP buyers over crypto exchanges, and Ripple's other distributions in exchange for labor and services did not involve the offer or sale of securities under the SEC v. Howe, yada yada. In the meet and confer process, when Ripple and the SEC met up, the Ripple guys indicated that they would set forth their position as to these requests in their response to this letter. Interlocutory review is warranted here. These two issues involve controlling questions of law on which there is substantial ground for differences in opinion, which is an interesting statement, as reflected by an intra-district split that has already developed. So they're already starting to talk about the Terraform case, in which the Terraform judge does not agree with the Ripple SEC judge, which I think is a low blow, a very low blow, especially if you start thinking about how this judge is going to take it up. Again, let's take it a step back, right? I've been looking at all these pieces over on Twitter where people are starting to find out that the judges in this district are not often agreeing with one another, but that Judge Torres usually has a pretty solid opinion and does not mess around. So the fact that the SEC is coming up and saying, hey, this judge right here, this statement, wrong. Because look at that, right? Look at what the other judge said. I don't know if they're going to be really appreciative of all this. I don't think Judge Torres is going to like that at all, that she's being played with so much, because she made it extremely clear. And again, guys, remember, she added some lawsuits that she didn't have to add. That's how certain she was of her decision, at least on the former, with regards to XRP over exchanges. So I don't think anything is going to change. But again, the SEC, following their own scheme, has to keep making bad decisions. Otherwise, they wouldn't be the SEC. Again, it says rejecting the approach recently adopted. So they basically include the fact that this new judge, I don't remember his name, it doesn't matter, in the SEC v. Terraform Labs case is actually denying this, rejecting the approach recently adopted by the order's programmatic sales ruling. Timely appellate review is particularly warranted given the numbers of actions currently pending that may be affected by how the Court of Appeals resolves these issues, which is interesting because indeed a lot of cryptos are weighing on the idea that Ripple won this and that all these sales over exchanges are fine. And the SEC keeps on battling through even against Hex right now, and like we see against Terraform Labs. So it is quite important, which is why the decisions are rather quick. And once more, if any SEC appeal from a final judgment, should this motion be denied, results in a reversal in whole or in part, interlocutory review would also aid the court and parties in simplifying any possible trial and avoiding the possibility of two trials and related piecemeal litigation. Indeed, were the courts of appeal to reverse and or remand some portion of the case, its ruling would impact the substance and manner of any trial that might occur. The SEC seeks to expedient and efficient ultimate resolution of this litigation, and thus, I'm messing this up, I don't know why, and has thus proposed a briefing schedule that will permit the court to swiftly rule on the proposed motion. Damn. Actually, something is interesting, right? I've been reading for a little bit, and it says the SEC will need to seek such discovery, which is in the idea that, before, basically that they need to discover more and see some more pieces. Before a final judgment may issue, a remedies phase will occur. This will call for several likely resource-intensive components, fact and expert discovery, related motion practice, and briefing as to injunctions, disgorgement, and civil penalties. By way of example, the parties previously agreed to postpone Daubert briefing as to a defense expert whose testimony supposedly relates to disgorgement under something. The SEC anticipates that discovery and briefing as to disgorgement will also raise an array of factual and legal issues. And because the parties could not previously conduct discovery into Ripple's post-complaint conduct, the SEC will need to seek such discovery relevant to injunctive and monetary relief. Ripple's own publicly available XRP Markets report represents that since this lawsuit was filed, Ripple has continued to sell XRP only in connection with ODL transactions, totaling approximately $3 billion in net sales. See the report here of Q1 2023. So they're trying to say right now that Ripple continued on selling, which again was allowed. The court has held that Ripple's ODL transactions violated Section 5, which again is not actually true, at least as far as I know, right? Because right now what they're trying to say is that ODL itself transactions of this on-demand liquidity violate something. I'm not so sure exactly how that would be the case. I guess it depends on exactly how the ODL sales are done. If it's Ripple selling to a party directly with a contract for the purposes of ODL, then I guess that was ruled by the judge. But in theory, the on-demand liquidity solution can't be, right? But Ripple's publicly suggested that it will contest and seek to limit any remedies that may be proper arising from these ongoing ODL sales, which is, again, for the purpose of facilitating these ODL corridors with the XRP, for as far as understood, stating that even though Ripple is a U.S. company, its current ODL sales lack a U.S. nexus, of which they're quoting David Schwartz. They're looking through Twitter. If Ripple intends to invoke Morrison v. Australia with respect to monetary relief for its ODL sales, as it did with respect to programmatic sales, substantial discovery could be necessary to determine the validity of such claims. So they're saying we need to dive a lot deeper. We need a lot more information. We need to look deep into Ripple's, stuff or other stuff. I'm not sure exactly which discovery. They just say it's substantial. They say it'd need a lot of time to look into everything. Ripple itself has accordingly proclaimed that the conclusion of the suit could take years, which, again, was talking about the idea that an appeal, if filed now or if filed in the future, would take a significant amount of time to finish. And that's, again, what the SEC is now also stating, that they need a lot of time to look over everything. Moreover, this court reserved judgment on certain aiding and abetting claims, and the scope of the individual defendant's liability could be affected or informed by appellate review of the order. Waiting for a final judgment means that should the courts of appeals reverse or remand this court, we need to redo remedies phase, discovery and litigation, and any intervening trial. So I'm thinking what they're saying is we need to postpone this whole trial situation to whenever this is done, because otherwise everything would have to be redone. And again, the earlier two statements were already said, but the third one, a new one now, is an immediate appeal from the order may materially advance the ultimate termination of the lawsuit. All right. Anyway, the rest is not so important. It's just more explaining. What is interesting is at the bottom right here, the SEC respectfully proposes a briefing schedule whereby the SEC files its opening brief on August 18th, 2023, which is 8 days from now, 2 days after defendant's response to this letter is due. Damn, that's 2 days already. Defendant's opposition is due 14 days thereafter, pursuant to Local Rule 6.1 on September 1st, and the SEC's reply is due 7 days thereafter on September 8th. Ooh, damn. Ooh, damn, da shakalaka boom boom. Damn. All right, so that's about it for what we got right now. I will again say, make sure you put that notification bell on so I can update you whenever something crazy happens. I'm just quickly looking through some additional lawyers to see if anybody stated something interesting. For as far as I'm aware, only people are saying, hey, the Bitcoin maximalists will be overjoyed by the fact that an appeal was brought up. However, again, the appeal is not being granted. It's just them requesting. Bill says they actually waited until she made the pre-trial orders to file a motion for leave to file an intellectual appeal, and to stay the pre-trial order she just made. Don't give them leave, Judge. So yeah, indeed, they wanted to appeal probably a little bit earlier, but they're waiting for the judge to put up a schedule. And a little while ago, another lawyer, Fred Rispoli, said this is huge in appeal context. So long as the SEC does not attempt an intellectual appeal, which they did, or does and it's denied, XRP, not a security holding, is set in stone through late 2025 at the earliest. But again, they did file an appeal. And it's actually kind of funny as well, I'm not going to lie, that the SEC did this exactly at one of the pumps for XRP. I mean, just for fun, right? XRP was doing bad for the entire week. It was coming down. Finally, all right, it's been like a day of pumping up, and the SEC is like, you know what? Let's smack him down. We don't like pumps around here. Well, they do like pumps, but only if it's in their own benefit, I guess. Because again, you got to remember, these guys made millions of dollars with some of the shenanigans they've done with, for example, Ethereum, but let's not talk about that today. Let's keep that for another day, another time. And like I said, guys, make sure you put the notification bell on and go ahead and press the like button if you enjoyed the video, because I'll keep you up to date with everything that's going on. And I'll also keep you up to date with whatever is responded to this little appeal, which we should get an update for in about 2 days, but perhaps even earlier, because Ripple's pretty fast with it. Price moving down ever so slightly, which is to be expected because, again, fear. But I don't think XRP is going anywhere. And I'll get you guys an update as more lawyers respond over the next couple of hours. So stay tuned and make sure, like I said, you go ahead and press that notification bell. Put it on so you never miss anything, all right? Because what if something crazy happens? What if another lawsuit gets filed? Whatever. You want to be notified as soon as possible. There we go.